makes them burn.
The Chief Administrative Law Judge of the Federal Maritime Commission just awarded a party almost $10 million, and the industry is aflutter with discussion. So let's cut through the noise. Let's talk about the cases, what it isn't, and why you should maybe just be a little careful relying on it just yet, right? I keep saying that about the ALJ decisions. Just be careful relying on it just yet. Hi, welcome to By Land and By Sea, an attorney breaking down the week in supply chain, presented by the Maritime Professor, me. I'm Lauren Began, founder of the Maritime Professor and Squall Strategies, and I'm your favorite maritime attorney. Join me every week as we walk through both ocean transport and surface transport topics in the wild world of supply chain. As always, the guidance here is general and for educational purposes only. It should not be construed to be legal advice, and there is no attorney-client privilege created by this video. If you need an attorney, contact an attorney. But before we get into the discussion of the day, let's go through my top 3 stories of the week. All right, story number 1. Look, I put this on our list last week. We are still on FMC rulemaking watch. Did you know that next week is already June 16th? What's June 16th? Well, if you watch By Land and By Sea, you know it's 1 year past the signing of the passage of OSRA, the Ocean Shipping Reform Act of 2022. It was signed in June 16th, 2022, which means despite the FMC not strictly adhering to the congressional rulemaking deadlines, and for good reason. Look, I'm not digging them on that for letting the deadline slide. I don't know. I think that the FMC probably has June 16th in its sights as trying to be close to it, even if they're not finalizing all of their rulemakings. I think they have June 16th in their sights. And I would bet that they're trying to release the next round of language for the next 2 rulemakings, at least 2 rulemakings next week or closely thereafter, right? So June 16th is Friday. So maybe we'll see it. Maybe we'll see it before June 16th. Maybe we'll see it just after, the week after. But look, what am I expecting here? I'm expecting the supplemental notice of proposed rulemaking from the unreasonable refusal to deal or negotiate with respect to vessel space accommodations, and probably the final rule, the final text for the detention and demurrage billing requirements rule. We've seen and we've heard in hearings, I think it was Chairman Maffei at the congressional hearing basically say that these are kind of moving together, right? Not necessarily together, but they're likely to be released together, which means we're all about to get pretty busy reading through and understanding and dissecting FMC intent and interpretation of the statutory authority through these regulations. Or, really said another way, how the FMC thinks these requirements should be implemented and adhered to in the industry. So that's the unreasonable refusal to deal or negotiate with respect to vessel space accommodations and detention and demurrage billing requirements. So later today in the episode, we're going to be talking about some case law that attempts to further define the parameters of unreasonable refusal to deal or negotiate. And I've said it before. Look, it seems like the FMC prefers the rulemakings to be guardrails and the case law to be where you kind of really jump into the specifics. So maybe we'll see that. Maybe we'll see the rulemaking be a little bit more parameters, guardrails, less prescriptive, and then they're going to let the case law kind of fill in and be the case-by-case basis. At least in this instance, this is what happened and this is how we ruled. But look, okay, let's do a quick helicopter view. We're diving right in here. So let's do a quick helicopter view. Let's pull it all back. What are we generally talking about, right? So, okay, so the passage of OSRA 2022, last year, June 16th, we really started watching 3 major rulemakings at that time that Congress had assigned to the FMC. So the first one was the unreasonable refusal to deal or negotiate with respect to vessel space accommodations. That one was required to be started right away. Detention and demurrage billing requirements, that one was also required to be started. I think that was 45 days after the passing of the bill. And then the third one that we were watching, and we continue to watch, is the unfair, unjustly discriminatory methods, which is defining unfair, unjustly discriminatory methods under the Shipping Act. That one we still haven't received any language on. So the first two, we have language, right? The first was required, the unreasonable refusal to deal or negotiate with respect to vessel space accommodations was required to be completed by December 16th, 2022. So it had a 6-month post-OSRA signing deadline. But at the time, Chairman Dan Maffei, we've talked about this a bunch, said getting it right is more important than getting it fast. And he's also said that this is kind of a tricky rulemaking to get right, and they really want to make sure that they get this one right, this unreasonable refusal to deal or negotiate with respect to vessel space accommodations. Initially, it was kind of intended for exports, but it's been kind of, it's opened up to both imports and exports and just general refusal to deal or negotiate with respect to vessel space accommodations. Remember that this one had the documented export strategy. What does that mean? Was some of the comments that were coming in. So there were still some things, there are still some things to iron out. So what they're going to be doing is a supplemental notice of proposed rulemaking, which means they're going to be doing another open comment period. We're still kind of in a continuing on, but same phase of the rulemaking. So we're in the notice of proposed rulemaking version 2, which they're calling the supplemental notice of proposed rulemaking. So what's going to happen at this next stage? They're going to release revised text based on some of the comments that came in, and they're going to say, look, we would love new comments. Let us know what you think about these things that we've interpreted from what you've said from your comments, that we've revised in our language. What do you think? This is not probably going to be the final rulemaking. It sounds like everybody is still kind of on board for the supplemental notice of proposed rulemaking. And that's what we're going to see. We're going to be kind of version number 2 of the same thing we went through last winter or last fall. What do you think about the language in this unreasonable refusal to deal or negotiate with respect to vessel space accommodations? That's just the first rule. The second rule I'm expecting to come out is the detention and demurrage billing. So look, remember this one had over 180 comments filed when that last comment period closed last December. So it takes a while to sort through all of that. I really think that we're going to be getting the final text out, hopefully next week, maybe the week after. But that was required to be finished up by OSRA 22, the 1-year deadline. It had a 1-year completion. So, I mean, technically, I guess if you release it on Thursday or Friday next week, you're still within that 1 year. Although what I expect is it's probably going to have a 30-day, 60-day implementation period, meaning that it won't be enforceable upon publication, but it'll be enforced 30 or 60 days after that final text is released. There's still one more small bite at the apple here, even if it's a final text, even if it's a final rule, that significantly adverse comments may still stop a detention and demurrage billing rulemaking from becoming final. It's a smaller bite at the apple, but there's still an opportunity, probably a small opportunity for the review of the final text. And if you have some significant problems with it, that's still, it's not a rule yet, right? The enforcement date is likely to be 30, 60, whatever it is, date from the publication date of this final rule. So all that to say, it's not final yet. Even if we get our final text next week or the week after, there's still a small chance if there's something that's significantly causing you problems. But we'll see. I'm just excited to see some language, right? I think we've all been waiting for it. We've been waiting about 6 months now, so this will be exciting. Like I said, the third rule we haven't seen any text on yet. So unfair or unjustly discriminatory methods. I said this last week. I think this is going to be a really tricky rulemaking to write proposed text on, and kind of overlaps with some of the others, but I don't know. Hopefully we'll see this. I remember seeing in the budget document, I believe, from the FMC, that they had kind of an intended July or August if we don't see it in June. But this summer, I'm expecting to see something. So yeah. I'll keep watching. I'll let you know. Hopefully next week we'll be doing a roundup of rule text. We'll see. All right, story number 2. That was a big story number 1, and there's nothing to report yet. We're still just waiting. All right, story number 2. The ILWU and the PMA. So I kind of mentioned it last week that there was some rumblings starting again. Obviously, the expired contract is still expired. There are no new negotiations. This is ongoing, but it seems that the tensions are rising, right? So last week on Friday, there was some initial talk of slowdowns at ports due to decreased labor at the ports and potential port closures. This week, it seems to center a little bit more on the ILWU. saying that they haven't had a raise in 4 years, and the Pacific Maritime Association there was a report saying that the average salary for an ILW worker was $200,000. But then if you follow Dr. Sal Mercogliano, he was saying that he's received some kind of organic feedback, a comment on one of his posts from somebody saying that, look, the $200,000 average salary is not correct. That's not what people make. So, I mean, again, right, there's more questions here. I think the biggest question that really is looming on people's minds outside of being curious of the specifics is what happens with detention and demurrage if the port shuts down for a strike, right? I think that's always kind of been the question. But now we're getting a little bit closer to it. Whether we're going to have a strike or not, I don't know. I don't think anybody knows. Maybe not likely, but who knows? You know what? Here we are. We're almost a year into the contract expiration. It was June 30th last year. July 1st was the first day of no contract, and here we are, the month of June. So obviously there's other questions looming as well, but it seems that this question is rising to the top of like who pays for a strike, right? Who pays for the demurrage or detention during a strike? I'm not sure if we really have a good answer for this yet either. Would a strike be part of the seemingly building precedent of a general port closure? We've heard from the Evergreen case, weekends and holidays on returns. We've seen some industry advisories saying that they wouldn't be charging during that time, but that's for general port closures, right? Would this be considered a general port closure? Or would it be maybe considered a force majeure, act of God? Does this kind of bump into a category of hurricanes and earthquakes and significant shutdowns for things outside of anybody's control? And I guess the follow-up question is, does it have a different application then, right? Do force majeure and act of God, and is that outside of a general port closure, or is that kind of anticipated by those general port closure Evergreen case type rules? I don't know. These are some pretty good questions. I think that these are the really crux of the concern on what happens. Where's my stuff and who's paying for it if it gets stuck again? Because everybody remembers just a few years ago. So maybe we'll get some clarity on this with the FMC's D&D final rule text. Like I said, hopefully this week, hopefully next week, right? This is already Friday. Hopefully next week before June 16th, maybe shortly after. Maybe they will talk about the detention and demurrage in a strike atmosphere or a act of God. I don't know. I'm interested to see that text. And I'm also interested to see, do we get any industry advisories over what happens if a strike happens? I think everybody wants clarity and predictability here. So that's just something that to me, that's the largest question that people are going to be kind of asking. What if a strike happens, who's paying for what here? We'll see. All right, story number 3. Let's switch over to the Panama Canal, shall we? So the Panama Canal, if you haven't heard, I'm sure you have, is experiencing droughts not seen in more than 70 years. And it's limiting the drafts that vessels are able to have going through there. We're down to 44 feet. 44 feet of a draft. That's not much. I mean, it sounds huge, right? But these vessels are enormous. And it's actually expected to go lower to potentially 43.5 feet. So even another half a foot down in late June. Reportedly, this is due to drought conditions being experienced by the region and the feeder lakes, particularly the Gatun Lake, the Gatun Lake, being the driest they've been and possibly expected to get worse due to the return of the El Nino this year, which brings heat and therefore more dry conditions to the region. So why is all this important? Why are we so focused on the Panama Canal with these lower drafts? The smaller the ships or the less full the ships are allowed to traverse if the draft level gets lower, right? I mean, you can't, these big ships that are fully loaded, they sink, where they kind of settle down, right? They draw a bigger draft. So you either half load them, lesser load them, or you send smaller ships through this area, the Panama Canal, which all of that means less capacity being able to get through, right? Less space available. And what happens when capacity is restricted? I mean, this is basic principles of economics. We all learned it during the COVID crisis, and hopefully we won't get anywhere near it again. But look, if you're restricting capacity, then prices are possible to go up and maybe even likely to go up. Or there's, now we're getting a little bit more savvy to it all. I think the industry is looking at diversification of routing, sought by some of the shippers as well. So it's not just, you're not stuck necessarily, but it's not great. So look, there's not a lot of answers here yet. I did want to just highlight this to make sure that this was on your radar of things to watch. According to G-Captain, they were using the EEC data. They said a pro forma round trip for a Panama Canal loop from Asia to U.S. East Coast generally takes 77 days, compared to if you were to go through the Suez Canal, it's an 84-day average. So 77, 84, look, that's an extra week. That's an extra 7 days. We're already talking about over 2 months of that route, 77 to 84. That's a lot of days. But those extra weeks matter. They add up. So something to watch. The drought of the Panama Canal is certainly something that's concerning and something to watch. So, but you know what? Let's get into the meat and potatoes of the day here, right? We've got a lot going on. And all right, before we start into this case, I just want to say there is a lot happening here. There's a lot happening here. We have OJ Commerce and Hamburg Süd, and there's been an initial decision issued by the administrative law judge. But it's just that. It's an initial decision, which means the parties still have an opportunity 22 days from the date of issuance of this initial decision to file exceptions, which means to file an appeal. And on top of that, even if the parties don't file an appeal, which this is a pretty contentious case, so I almost expect that an appeal would be filed. Even if the parties don't file an appeal, the commission, the full Federal Maritime Commission, has 30 days from the date of issuance to review it as a full commission. And typically when these are larger cases, kind of bigger ramifications, the commission likes to review them on sua sponte review is what it's called, because they want to really weigh in on some of these larger things. The administrative law judge is just one person. And so then if you pull it out, sua sponte review, you get all 5 commissioners being able to weigh in on novel issues, especially when there's novel issues. So all of that to say, this initial decision that was issued actually on the 7th, so 2 days ago on Wednesday, was the official issuance of this initial decision from the administrative law judge. All that to say, it's not final yet. It's an initial decision issued by the administrative law judge. But to her credit, right, she's been with the case since it was first filed November 23, 2021, when the complaint was first received by the commission. So, she's been with it the whole time, not to discredit her abilities here. But I'm just saying there's still a few very major things that can happen in the next 30 days. And until those 30 days have passed, this is not a final decision on behalf of the commission. This is an initial decision on behalf of the administrative law judge. Okay. I just always want to clear that up because I feel like sometimes a day or two after some of these initial decisions gets released, everyone's saying this is precedent. Well, we have a few weeks, and then you can start saying that. But so what's happening here? What happened in this case? So this week, the Federal Maritime Commission's ALJ, the administrative law judge, released an initial decision that awarded $9.8 million, almost $10 million to OJ Commerce in their lawsuit against Hamburg Süd, which, as we know, is now part of Maersk. And they were stating that Hamburg Süd violated the Shipping Act under statutory requirements related to retaliation and refusal to deal. That's what the ALJ cited here. Okay, so who are these people? OJ Commerce is an e-commerce company offering goods and home, kitchen, garden tools, office equipment, pets, food, and miscellaneous household supplies, according to their website. Hamburg Süd, now part of Maersk, as we know, is an ocean carrier. So a little procedural history here. The complaint had a whole bunch of Shipping Act violations listed initially, and quite a few were dismissed kind of in those initial rounds. Those that remained were unreasonable practices, retaliation, and refusal to deal. The unreasonable practices section was ultimately resolved by Hamburg Süd refunding demurrage charges at issue that were part of that Shipping Act violation. So this initial decision is really only relating to two claims being addressed in this initial decision: retaliation and refusal to deal, which is what, along with the high price tag, makes this case such a marquee case, right? That it's retaliation and refusal to deal. And like I said previously, rulemakings, as of recently, and kind of in general, the FMC tends to do guardrails, and the case law is where we get a little bit more specific. So what this case does is it kind of starts to look into the elements of retaliation, the elements of refusal to deal, and when and under what fact pattern the FMC will start to make decisions for or against that. So as the administrative law judge is introducing the case, she says, and I'm going to be quoting quite a bit from the actual initial decision because it's a very complicated, long, over 60-page initial decision. So I want to make sure that I'm being fair to the full initial decision and stating what she says, and then I'll break it down for you. But I want to make sure that you at least get some of this original language. So the ALJ, as she's introducing the case, says, this case raises novel legal issues about refusal to deal claims, retaliation claims, and calculation of reparations. In addition, the parties disagree about many of the factual allegations. And that's where it gets complicated, of course, right? Continuing, the parties heavily litigated this proceeding with multiple motions to compel evidence filed. Indeed, both parties allege that the other party violated discovery requirements. So in other words, the ALJ is setting this up to basically say, look, this has been pretty contentious. Now, look, the case was just released. I'm expecting the exceptions, the appeal, like I said, would be filed, especially after the ALJ is saying that, especially if this case was that contentious during the proceeding. So this is still very much a moving target, despite a lot of people hailing this as a final statement from the FMC. To be clear, it's not a final statement from the FMC, not until that 22-day for exceptions or appeal, or the 30-day time period for the full FMC to sua sponte, pull the case and review it as a full commission. It remains an initial decision until that time has passed, and then it turns into a final decision. But we're not there yet. We are, 22, it's been 2 days since it was released, so we're 20 days or 28 days away from the FMC final decision that would otherwise be if everybody just left it alone. But like I said, I don't expect this to just be left alone. So I'm going to pull some of the discussion from the case here and then break it down. Look, I just want to start this whole thing. This is not going to be a fully comprehensive review. This is a pretty complicated case. This is really going to be more of an overall presentation of what the case is really about. Look, perhaps in another episode, we'll go into more detail. I want to keep it simple, digestible. I want to translate some of it so that you get the gist of the case, but I also don't want to complicate or overly confuse or misrepresent, right? So I encourage you to go read the case yourself. I think that this one is a very, very interesting one. Obviously, it's going to have some novel issues in it, and certainly some interesting discussions. All right, so from the ALJ's initial decision. So OJC, which is OJ Commerce, OJC asserts that after, and to clarify some of these sections, I'm going to kind of fill in with what they're saying. So basically, OJC asserts that Hamburg sued, received a demand letter, and after that, from OJC's attorneys threatening to file an FMC complaint, Hamburg refused to deal and retaliated both by refusing to fulfill existing contractual obligations under a 2020 to 2021 service contract and by refusing to renew or negotiate a 2021-2022 service contract. Hamburg sued contends that it did not retaliate or refuse to deal or negotiate, and that OJC fails to prove damages with reasonable certainty, and that an adverse decision would require it to consent to any terms demanded by a shipper. They're basically saying, OJC's Commerce is saying, they sent a letter over to Hamburg saying, fulfill existing terms of our contract or we'll sue you at the FMC. And OJ Commerce is saying, look, after that threat of litigation, Hamburg sued, refused to deal, and retaliated by not only not fulfilling their existing service contract, but refused to even negotiate a new contract with them. Hamburg said, we didn't do that. They just didn't agree to acceptable terms for a new contract. So the ALJ addresses that. So she continues. Commission case law is clear that an ocean common carrier does not have a duty to grant a contract to every potential party. right? So that's what she said. Commission case law is clear that an ocean common carrier does not have a duty to grant a contract to every potential party. You don't have to result in a contract with every negotiation. So she continues. However, long-standing commission precedent prohibits common carriers from shutting out any person for reasons having no relation to legitimate transportation-related factors and from retaliating against shippers. So that's where she's starting to lay out some of those factors, right? And they need to be transportation-related factors, legitimate transportation-related factors, as being the reason for not going forward that's part of the retaliation or unreasonable refusal to deal. As outlined in detail below, the evidence shows that here, Hamburg's decision on April 29, 2021, to disengage from fulfilling the 2020 to 2021 service contract, negotiating a 2021-2022 service contract, was made due to the litigation risk posed by OJC, which under these facts is not a legitimate transportation-related factor. The specific conduct in the record here establishes both the refusal to deal and retaliation claims. So that's what the ALJ is saying she made her decision based on. She's saying that it was the threat of litigation that caused Hamburg Süd to disengage from not only fulfilling their current contract, but negotiating a new contract, and that decision was made due to a litigation risk posed by OJC. She's saying, look, that's not a legitimate transportation-related factor, and therefore that's refusal to deal and retaliation. And this is like I said, this gets complicated. There are multiple pages dissecting and discussing refusal to deal and retaliation claims. So I encourage you to read the actual case, the actual initial decision yourself. There's also discussion over contention on how damages should be determined, and that also gets complicated. Everything in here, once you start diving in, you're like, oh yeah, this is interesting. So I'm going to actually stick to just the retaliation and refusal to deal pieces. Essentially, the ALJ gets to the number 4.9 million as the actual injury. Okay, 4.9. I thought we said 9.8. It gets interesting again. The administrative law judge says, because OJC establishes a violation of the anti-retaliation provision, additional damages may be awarded. Okay, so the actual injury determined was 4.9 million. Given that the violation was knowing and willful, double damages are found to be appropriate. Accordingly, OJC is awarded reparations of 9.8 million from Hamburg Süd. She doubled the actual injury here. It was 4.9 and she doubled it, saying it was willful and knowing of a violation. That's kind of wild, right? All right, so continuing on in the initial decision, she starts to kind of outline some of these things. So she talks about where OJC sends the demands letter, the demand letter over to Hamburg Süd. She references part of what they said, basically saying immediately honor the service contract and minimum TEU quantities. Failure to cure may result in legal action. So, that's kind of typical language of a demand letter. But apparently there may have been some discrepancies on an additional 2 TEUs at that point. And like I said, I don't want to go too far into the weeds here and too far into the specifics. But there was some discussion still between the parties at that point, apparently about 2 TEUs that may not have formal documentation for the additional TEUs. And that might have been part of the not fulfilling the current contract. So, all right, let's pull it back here. So what were the actual sections of law at issue here, right? So we're talking about retaliation and unreasonable refusal to deal or negotiate. What are the actual sections of law? So it's under the statute. It's under 41104A. The 2 claims in the proceeding are in general, so under 41104A, in general, a common carrier, either alone or in conjunction with any other person directly or indirectly, shall not. Subsection 3 and subsection 10 are what's highlighted here. So 3 is retaliate against a shipper by refusing or threatening to refuse cargo space accommodations when available, or resort to other unfair or unjustly discriminatory methods because the shipper has patronized another carrier or has filed a complaint or for any other reason. Okay, those are the listed reasons for retaliation and what might qualify as retaliation, but they have the catch-all for any other reason. And then you get down to subsection 10, a common carrier, either alone or in conjunction with any other person, directly or indirectly, shall not unreasonably refuse to deal or negotiate. General. That's why we're kind of waiting on that rulemaking, because that's going to be defining a little bit more of what unreasonably refusal to deal or negotiate looks like. So the next natural question, right, is you may be asking about the recent developments from OSRA and the pending rulemakings. The ALJ addresses that. OJC filed the amended complaint prior to the June 16, 2022 changes to the Shipping Act. In the Ocean Shipping Reform Act of 2022, Congress modified Section 41104A, subsection 3, to unreasonably refuse cargo space accommodations when available or resort to other unfair or unjustly discriminatory methods. And subsection 10 was amended to unreasonably refuse to deal or negotiate, including with respect to vessel space accommodations provided by an ocean common carrier. This is still quoted from the ALJ language. These changes do not apply to this proceeding and are not discussed. In addition, in September of 2022, the Commission issued a refusal to deal notice of proposed rulemaking, as we know. Notice of proposed rulemaking definition: unreasonable refusal to deal or negotiate with respect to vessel space accommodations provided by an ocean common carrier. The proposed rule is not binding, and it has not been adopted because it's still a proposed rule. So that was all included in the ALJ's initial decision. She talks about, I know there's a lot going on currently in the regulatory side of this, but we are not there. This was pre all of that. So then she starts breaking it down. She has a whole section on refusal to deal. She said OJC asserts that Hamburg unlawfully refused to deal and negotiate with OJC, and that Hamburg's after-the-fact pretext for its retaliation and refusal to deal are all baseless. Hamburg contends that it did not refuse to deal and that it did not refuse to negotiate, asserting that there was never a meeting of the minds on the material terms of the contract. All right, so she's starting to outline kind of the basic things. She says Section 41104A10 prohibits a common carrier from unreasonably refusing to deal or negotiate. The Commission has found that a common carrier should refrain from shutting out any persons for reasons having no relation to legitimate transportation factors. So to establish a violation of Section 41104A10, the complainant must establish that respondents are common carriers, respondents refused to deal or negotiate, and such refusal was unreasonable. So she's outlining the elements of this refuse to deal or negotiate. Hamburg contends that they, of course, did not shut out OJC, but rather transported 180 of the 200 FFEs they committed to transport during the terms of the service contract. This is where it's going to get a little bit in the weeds. I'm going to kind of skip this, but basically they're saying that they did not refuse to negotiate. Their actions were reasonable, and there's no evidence that Hamburg Süd refused to communicate with OJC during the contract term. They're saying there was no agreement on minimum volume commitment, trade lanes, and rates, and parties agreed on rates, and Hamburg Süd transported OJC's cargo from Asia and Brazil in 2021 and 2022 after OJC threatened to sue. So they're saying, look, all of this is kind of baseless. Then the ALJ, the administrative law judge, highlighted that there were some back and forth emails within Hamburg Süd that discussed the threat of litigation and essentially based the decision to not engage on that. So this is where it got interesting. So she's kind of saying, here's what Hamburg Süd said, but then here's an email that we have on file that says, this is internal email, that is how she's presenting it. We should not engage, fully agree, we should not engage in any renewal discussions with customer in light of the potential litigation. I would also not provide them with space under the existing contract. I mean, that's no good, right? If that's true, if that email is true and all of that. So she's putting it in the initial decision. So there it is. And it seems like that's what she's basing it on. Again, I don't want to get too far into the actual specifics. Go read the case yourself. You can skim through and find the sections and really kind of go into those elements. But that's the first part. So reasonableness. The Commission, the ALJ says, the Commission recently discussed its prior application of the term reasonableness with regard to a refusal to deal or negotiate claim, stating, case law indicates that reasonableness of the refusal to deal or negotiate has historically been interpreted broadly in this context, with courts deferring to the Commission's reading of that term and administering its statutes and regulations. The Commission has previously found reasonable those decisions that are connected to a legitimate business decision or motivated by legitimate transportation factors. Reasonableness can be given its dictionary definition, but is judged on a case-by-case basis with particular attention paid to the relevant circumstances. The Commission has said that a just and reasonable practice is one otherwise lawful but not excessive and suited to the end in view. Transportation-related factors can include, without limitation, the character of the cargo, vessel safety and stability, operational schedules, and the adequacy of facilities. So those are some interesting examples of reasonableness, right? Continuing on from the ALJ initial decision. Generally, however, transportation-related factors relate to the characteristics of the cargo or vessel, not the status of the shipper. The Commission has found various situations that inform what refusing to deal entails. It has found that a common carrier must avoid shutting out any person or party for reasons not connected to legitimate transportation factors. A common carrier must therefore give actual consideration to the other party's efforts or attempts at negotiation. So, for example, a common carrier's repeated refusal to respond to email or telephone requests for a negotiation over an extended period of time may be viewed as an unreasonable method of shutting another party out. Similarly, there must be an affirmative act by a party to deal or engage in negotiations with a common carrier. Commercial convenience alone is not a reasonable basis for a common carrier's refusal to deal or negotiate. A common carrier granting special treatment to one party over another because that party is a regular customer is likewise also likely to be viewed as unreasonable. So that's kind of going through the unreasonable, reasonable, refusal to deal. So then she switches over to retaliation. And I'm not going through these fully in depth. I'm just highlighting them so that you get a little curious, you get a little interested, and you go check out the initial decision yourself. So retaliation, that comes under Section 41104A3, subsection 3, provides a common carrier either alone or in conjunction with any other person directly or indirectly may not retaliate against a shipper by refusing or threatening to refuse cargo space accommodations when available or resort to other unfair or unjust discriminatory methods because the shipper has patronized another carrier or has filed a complaint or for any other reason. So continuing on from the ALJ's initial decision, therefore common carriers are prohibited from retaliating against the shipper by refusing or threatening to refuse cargo space accommodations when available, or resorting to other unfair or unjustly discriminatory methods because the shipper has patronized another carrier, the shipper has filed a complaint, or for any other reason. She continues on and says double damages may be available for violation of the anti-retaliation provision. So the ALJ introduced that the Commission recently concluded a policy statement on retaliation. So she's kind of building what the baseline of what she's going to be determining kind of the facts against here. So she said the Commission recently issued the statement on retaliation to clarify that it will interpret 46 U.S.C. 41104A3, so this is that subsection A3, the anti-retaliation provision broadly to effectuate Congress's intent that shippers feel free to air their grievances to the Commission and to address a new shipping practice and new forms of retaliation. The Commission concluded the policy statement with an example stating a complainant must show that a carrier engaged in prohibited conduct, so refusing cargo space accommodations or other unfair or unjustly discriminatory methods, with respect to a protected entity, a shipper, because the protected entity engaged in protected activity, patronizing other carriers, filing a complaint, or other activities of the same class. Continuing on, this section will address the retaliation arguments in this proceeding by discussing whether A, each respondent is a common carrier, B, respondents engaged in prohibited conduct by refusing or threatening to refuse cargo space accommodations when available or resorting to other unfair or unjustly discriminatory methods, C, complainant is a shipper, and D, complainant engaged in protected activity by patronizing another carrier or filing a complaint or for any other reason. The first two elements focus on respondents, while the last two elements focus on the complainant. She then goes through, so she's outlining these four elements. She then goes through all four of those elements and essentially says, look, they're all satisfied. So that's where we get to the ultimate determination that 9.8 million, right? Based on that 4.9 million initial actual injury gets doubled because she said, we have both retaliation and unreasonable refusal to deal. And ultimately, she says 9.8 million is awarded in part because of that email that said, look, we're not going to deal with them because they threaten litigation and this is too much of a risk. In part because of all of the elements that she goes through. And I mean, can't you see how this is a contentious case, right? This is certainly something that went back and forth for a while. I think we're going to see exceptions filed. I think we're going to see an appeal here. And I know that recently I keep saying, look, these initial decisions, you got to be careful. There's been some contentious ones, right? There's been some ones that we've even had amicus curiae briefs filed for the chassis case. That was an initial decision that now has exceptions filed. It's on appeal. So it kind of brings it back into pending category. Look, all of this discussion is not legal advice. This is all general and for educational purposes. I know that I get a little nervous on these days that we go over the case law because I want to make sure that you know that this is just general discussion. I don't think that these cases should be relied on just yet. They're not quite there yet. But this is interesting discussion, right? This is interesting. This is pretty in-depth on retaliation and unreasonable refusal to deal. And I think that it's starting to paint in the otherwise coloring book of lines, right? The rulemakings are kind of the sketch of the coloring book, the black and white lines. And then the case law brings in the color here. It's happening simultaneously, which is interesting because, like I said, we're in this post-OSRO world. We have the rulemakings out there. We have some changes, statutory changes that happened, small, but that happened to these very statutes that the ALJ is now kind of comparing the facts against. But in general, all of this is coming together to really illuminate and bring clarity or begin to bring clarity to these complicated areas. So look, as always, the guidance here is general and for educational purposes only. It should not be construed to be legal advice directly related to your matter. If you need an attorney, contact an attorney. But if you do have specific legal questions, feel free to reach out to me at my legal company, Squall Strategies. We went through a lot of case law today. Well, we went through a lot of kind of specifics in the case law, but it's not exhaustive. There's much more discussion here. I encourage you to go check it out yourself. I don't want to misrepresent anything that was in here. I just tried to catch some high-level things so that you kind of get a gist and a flavor for what was being determined in this case, and why I think that this initial decision is not quite done yet, that whether it's the exceptions filed or it's the FMC pulling a sua sponte review on it, my feeling is that this one is not done. So look, otherwise for the non-legal questions, the e-learning and general industry information and insights, come find me at the Maritime Professor. Again, this was general and educational purposes, not legal advice. So if you like these videos, let me know, comment, like, and share. If you want to listen to these episodes on demand or if you missed any previous episodes, check out the podcast by Land and by Sea, wherever you get your podcasts. If you prefer to see the video, they live on my YouTube page by Land and by Sea, presented by the Maritime Professor. And while you're at it, check out the website, themaritimeprofessor.com. So until next week, this is Lauren Began, the Maritime Professor, and you've just listened to By Land and by Sea. See you next time.